Good. So, hello. I'd like to welcome everybody online and also in the room to this webinar that we're broadcasting from Said Business School of Oxford University. I have the pleasure to run this webinar for Professor Mari Sako, who will talk about make and buy decisions in legal services and the impact that has on research and co-specialization and among suppliers at Fortune 500 firms. George, do you want to run the additional introduction? That was just the webinar introduction. If anyone has a problem with sound online or anything like that, please send that in that bubble so that we can do something about it. But usually everything should be fine.
Okay, well, good afternoon, and thank you for coming. And this is a seminar for Novak Drew Center at Oxford, and I'm going to present primarily a research paper that I've written together with George Kondrakis, who's sitting in the room, and Paul Valler, who's at Minnesota. It's really primarily a research paper. There is actually a paper that for anybody who is interested in reading a research paper, happy to circulate for comments. In fact, we're in the process of getting comments. But I'm also going to provide a little bit more in detail, in greater detail than in the paper, the legal context in which the study has been carried out. So it's in that spirit that I'm going to primarily talk about what might be called make or buy decisions more commonly, but actually make and buy decision. And I'll try and explain what that is, the difference between make and buy decision and make or buy decision, and provide a kind of theoretical framework around that, generate a set of hypotheses, but really talk a lot about the legal context before we delve into the quantitative data. And then some results, and then lots of implications. I think the bits that I would love your feedback on is your great knowledge about professional services generally, and understanding what make and buy decisions might look like in different corporate function contexts, but also how the theories matched with the data. Because the reason why this hasn't been done, I think, to date is in part to do with the inadequacy of the available data. And that's the key thing that we're trying to see if there is any alternative data out there, but also the ways in which we're trying to manipulate the data. Is that adequate or not? Okay, so let me jump right into the make and buy context. And I'm trying to go on to the next slide. Is there something I could do to just there? Okay, great. So a good starting point for anybody who's looking at the boundary of the firm and make or buy decision would refer to two really well-known theories. One is transaction cost economics, and the other one is resource-based view. So in the business school, we all know that transaction cost economics, as was framed by Williamson, was primarily about, if you remember, asset specificity and uncertainty that leads to opportunistic behavior, and as a result of that, attempts at making rather than buying in order to preempt opportunistic behavior. And transaction is the unit of analysis there. If we go all the way to the other side and look at the resource-based view of the firm, then we tend to think about a bundle of difficult to imitate resources that managers can utilize as a way of thinking about drawing the boundary firm. And here the entire firm is a unit of analysis. But what's common between these two theoretical frames is an analysis that leads to the choice of one optimal mode of sourcing. So whether it's to do with buying or making or allying, it's just one single thing that's the most optimal. Now, we want to move away from that to think about a situation where a particular set of inputs or services are both made and bought. And it's quite common for this to happen. If you think about, components like engines or services like insurance, that some are made and some are bought. And already within the management literature, there's quite a bit of prior work that's been done to identify the preconditions for simultaneous use of these multiple sourcing modes. So way back in 1949, Edelman talked about demand uncertainty. So it's the difficulty in predicting demand that would give you a surge as well as a trough in your demand fluctuating that would, be actually minimized if you do both make and buy. There's also work by Dutta and Heidi that sort of says that if you also made something that you're buying, then you have better know-how and better way of monitoring your supplier's performance and better bargaining power as a result. So that's an attempt at reducing information asymmetry between the buyer and supplier. A third might be a notion around overlapping expertise. So Parmigiani, more recently in her work on concurrent sourcing, emphasizes the importance of overlapping expertise between the buyer and the supplier as a way of making the buy and make choice a lot more fungible over time. And also Kaminska in her recent work would also focus on things like technological volatility, the fact that you're outsourcing everything might actually give you less insurance against new kinds of technology in the future. So you want to keep on making a little bit. And this notion lastly by Punaram et al. On complementarity knowledge. And this is complementarity knowledge between different sourcing modes. So if you bought and made at the same time, then it's more likely that you engage in mutual learning, transfer of best practices, across the firm's boundary. So there's some kind of complementarity and synergy that result out of it. So these are preconditions for why plural sourcing or concurrent sourcing or taper integration. There's lots and lots of different labels here, but we're going to try and settle on one. So I'm talking in terms of plural sourcing when I refer to multiple modes being used at the same time. There's not a huge amount of work that's been done that goes beyond identifying these preconditions to answer a very obvious logical follow-up question, which is, if you chose plural sourcing, then how do you decide on the mix of how much to buy and how much to sell? So if you have a set of V8 engines, how do you decide to buy 20% and make 80%, or the other way around, to buy 80% and make 20%? It's that kind of mixed question that we want to focus on in this paper. And we really nail down on two mechanisms for the determinants of these mixes. And one is the notion of resource co-specialization, and the other is the notion of supplier portfolio concentration. So I'll come to these two mechanisms in a minute. But before I do that, let me spend a little bit, and really as much as 5-10 minutes, spelling out the legal context and legal services context. So in management, and really kind of going back to Porter, do feel free to interrupt me at any time. Legal services are actually not part of the primary activity, unless you're a law firm, but part of the so-called support activities in this value chain diagram by Michael Porter. And so make or buy decisions traditionally have been, quite rightly, been focused on the analysis of the primary activity value chain and not so much in the support activities. In part, I think, because there's this notion that if you're in the support activities, then they're kind of fixed overheads and you don't really fiddle with that in terms of costs or, where to make and where to buy. But if you focus on these support activities, then, from a corporate legal department perspective, down at the bottom, the legal affairs department or the legal department, they're doing all kinds of activities that's to do with, patent filing, compliance work, contract review, litigation, corporate transactional work, regulatory filing, and corporate governance related work. And the question arises as to, what are the criteria that these legal counsels making to decide which activities to do in-house within the department and which activities to be sourced to typically law firms, but increasingly to non-law firm legal support activity providers like the legal process outsourcing firms. So with that in mind, I think the traditional way of thinking about the division of labor between the law firms on the one hand and the in-house legal department on the other is like this. That there's a bit of an overlap, but actually, what the two do are fairly separate in terms of what they're capable of doing, what their competitive advantage in doing, would be. And through interviews with about 52 general counsel, I came to the conclusion that the reality looks a lot more like this, that there's a huge amount of overlap between the two, and that, in fact, the choice is quite fungible. And so, the kind of work that only law firms can do, really big litigation cases or M&A cases might be that. And some things that only the in-house would do, really kind of boring, sort of document filing type, contract reviews or regulatory filing or employment law related documentation that you got to update, say, which could be done very simply by paralegals, maybe. But the majority of the work that I've listed in the previous diagram, that's to do with, compliance or patent filing or whatever, it could be done by either. And actually, in many cases, they're done by both, either in parallel or as teams. And that's where the analysis on make and buy and how much to make and how much to buy, I think, should be concentrated. So in terms of looking at, sure, yeah. Mm. In manufacturing context. Yeah, so I think I might want to sort of make a finer point around what constitutes a similar set of activities that for which you can, contract in or out. But if you are okay with the level analysis where there's a category of goods that look similar, like a set of V8 engines for different models, then I think that's precisely right. But it's a kind of revision in the kind of theoretical framing that we have away from our transaction cost economics to looking at a portfolio of transactions where there might be some interdependencies that this analysis, forces you to take seriously, I think. And corporate function, because you can put a set of activities, a particular kind of professional service activities in a corporate function, nobody's going to dispute about the boundary of what's in the legal department. It's a lot easier to do that, I think, than in a manufacturing context where, people have different views about what should be that kind of pot that you're looking at. So, yeah. But let me go through some of the kind of legal context in a slightly different way. So this isn't part of the research paper that I'm presenting now, but a slight digression from the prior work that I've done, understanding why it is that there's this debate around, firstly, the convergence of the panel review for law firms, but also the, the attempt at really controlling costs, legal costs on the part of commercial corporations, which are bringing work back in-house. So this is a kind of headline that kind of gives you some thought around, why use law firms at all if you can do everything in-house? Indeed, there are, things that have to be done out of house if you're Barclays Bank or any kind of big corporations like GE. But because of that kind of rise in external cost of sourcing legal services, there is indeed quite a general economy-wide trend. So this is ACC and Serengeti for the United States and Legal Week for the UK. And over a period that doesn't quite step into the financial crisis period, but you can see in the mid-2000 that this is actually percentage of external total, so it's going down. So actually, in fact, the trend is towards insourcing. So more corporations are actually relying on insourcing than outsourcing over time. But this is just a general average. And what I found by talking to, this is by value, yeah. So this is a budget. Yeah, that's right. And again, sticking to budget and monetary sums. So by visiting 52 legal counsel in Britain and the US, I summarized in this report, General Counsel with Power, that had some media coverage, that if you look at different sectors, but even within each of the sectors, like financial services or construction or retailing and wholesale, that there is quite a big range in the extent of insourcing or outsourcing as well. So that led me to sort of think about what's causing this divergence, right? So academics are in the business of not just capturing trends, but understanding, what are the explanatory factors for explaining the variations. I came to a quick sort of back of the envelope type of sort of typology where there seems to be some general counsel who are really externalizing and relying a lot on law firms to source their work. And then on the other, there were, other types of general counsel who were really trying to claw work back in-house as a way of controlling cost. And then overwhelming majority somewhere in the middle, these mid-ranges, many of them financial services actually, 40, 60%. And that's where the make and buy decisions can be made. So let me try and give you a flavor of what I found. And these are sort of, related to the preconditions for make and buy, in legal services. And they really are prevalent. So in many interviews I conducted, some would really talk about the need to rely on external counsel, particularly because of uncertain demand for legal services. If there's a huge, big ticket, bet the house kind of litigation or M&A that you can't predict, you can't just hire, 40 associates just like that, can them in a hotel room and look through, work in terms of rediscovery or and so that's where you need to rely on external, even if you might want to do everything in-house. Another interesting insight into the precondition for make and buy is the overlap in expertise. So this is actually an investment banking in-house lawyer who said to my question, what has to be done in-house? What types of work has to be done in-house? He says, nothing. So a few years ago, I said to my bosses that we can have, a debate around this and hire 200 more lawyers, bring more of the work in-house so we can fire all the in-house lawyers. And the two of you, the general counsel, the deputy general counsel, I guess, can manage all the outside counsel. So these are the two extremes. And the question is where to be in the middle. So that's precisely the make and buy decision that we're going to be examining in a minute. And then the knowledge complementarities between in-house and external lawyers is also quite prevalent in many examples. But, whenever I ask a question like, if you have a fairly important litigation case, what's the division of labor between the in-house and the external counsel in terms of each stages in the litigation case? And you have to start with actually devising a strategy for the litigation case, work out the tactics, and then think about who's going to do the actual document review, and then who's going to do the summary judgment, and the court obviously has some kind of timing around doing these things. Many cases they work as teams. Really, it's very difficult to assign one or the other, but there are some notions around complementarities and expertise with in-house really taking the lead and understanding what the corporation wants, the CEO and the board would want in terms of strategy, and the external counsel really interpreting what the court and even a specific judge might prefer as well. So I think that's one example of complementarities here. Okay. That's probably all I'm going to say by way of the legal context. And now I'm going to switch gear to a fairly academic paper format of having a set of hypotheses followed by some data. And then I'll come back right at the end to implications, not just for theory, but also for legal practice as well. Okay. Any questions or comments so far?
Is there any, in setting this out, you haven't necessarily, you've chosen something in the middle, say, litigation, M&A. What you haven't set out, of course, is that there may be logical regulatory reasons, right, which might be driving some, I could imagine, a shift, which would say, where you could actually see it driving in two different directions. So one might be that the increase in oversight for white-collar work and sort of forensic things is actually driving some of that work out of the firm that was previously done inside the firm and outside providers, because you want to show that you're doing what you might have done in the past is to investigate, determine, and put it outside. At the same time, the commodification of transactional work could be seen to be driving work into the firm. So you could actually have two trends, you can sort of identify potential trends that could be where you're switching work, and what the outcome would be from that.
Yeah.
Which you can see two tracks out, and they're kind of able to.
Yeah. Yeah.
But presumably that's not what you're really looking at in a sense. You're looking at this stuff in the middle where it is being driven by the commodification regulation of rather remains something where you have a choice. So it makes a lot where the point is we can do either.
Yeah. So, the two things that you said, commodification and regulation. So commodification itself could be affecting everything that happens in the middle, right? And I think it's indeed happening, right? So, the way that people think about contract review in a much more kind of process flow and project management kind of way, whether that's done in-house or out-of-house by law firms. I mean, I think that's being driven by cost pressure to an extent, but for all kinds of reasons, including the availability of technology and legal software that enables you to do that. So I think that applies. On the regulation side, these are potentially discrete changes. I mean, if there's much more reliance on compliance, for example, or much more volume that's generated out of regulatory filings, then again, if it's just a surge in volume, then I think it could be done either. But as you say, in some cases, I guess it's a legal requirement that you have a third party look at specific investigations anyway. So that's exclusively on the non-overlapping bit of the Venn diagram where only law firms can carry out. Yeah. Yeah. Yes.
I just wanted to ask, so it sounds kind of, you're getting a picture of this sliding scale here where a firm will just make it and move it over here and ask more. How actually liquid is that? I mean, has there been kind of a previous background study to show that you really can, on a case-by-case business, just say make or buy and not, it doesn't require a larger change in the infrastructure of the study to come in. This investment banker, obviously it's a special case, but he's saying we can hire him to go to lawyers. Is that really the case?
Yeah, so there's some obviously over time stickiness around. You don't necessarily, the head count is time dependent but very sticky. It's not known to hire and fire lawyers that easy, particularly if you're hiring them for in-house counsel over time. There are more flexible sources of legal input through contract lawyers and non-lawyer paralegals and others now. They're kind of contract specialists, who do contract review that used to be only done by lawyers, but are now in a separate contract department, not part of the legal department. All these things are happening. So I think it's become more flexible, but there is stickiness still built in. But in terms of, actually bringing the kind of work that used to be done by law firms back in-house or vice versa, I think that is evident in many different areas, including patent filing, for example. So, a boutique IP law firm might have done everything that goes from prior art search to actual, drawings and documentation for patenting all the way to patent execution. But in some cases, when some of the corporations which aren't the intensive, they brought work back in-house. In that some of the prior search could be done by in-house team, and some of the drawing and the actual documentation could be done by in-house team as well. So it is happening. Yeah. Right. So what we're doing is actually for each corporation understanding how the weight between make and buy have changed over time. I don't think we're necessarily dependent on changes over time. It's a panel data. So as you'll see, we're kind of looking at cross-sectional as well as over time changes. As you'll see, the over time change isn't huge for sure. Yeah. So that's a fair point. Yeah. Okay, so let me go through the two mechanisms that we feel are important in understanding the mix between buying and making, or the external and internal sourcing. So there's a whole a bunch of hypotheses which are to do with resource cost specialization, and then the other hypothesis that's to do with supplier portfolio concentration. So I'll go through each one of these reasonably briefly, and starting with the resource cost specialization. So the idea here is really to sort of say that co-specialization has synergies. So there's synergistic gains which you can really sort of create by maximizing the kind of interaction between different kinds of resources which are prevalent inside the firm. And so we're talking about here interaction between the legal resources which are inside the legal department and other kinds of resources in different departments. So with internationalization, one way of thinking about it is that as the number of countries in which the corporation operates increases, there's greater opportunity to create value from multi-jurisdictional and extraterritorial legal work. And the resource co-specialization bit of it is between the in-house legal department and, for example, the finance and accounting department. If you're thinking about how to think about exploiting regulatory arbitrage in international tax planning, for example, or it could be between the legal department and the strategic planning department if we want to think about identifying R&D, sorry, not R&D, M&A or FDI opportunities which are in themselves international. So here the proposition is that the more international presence there is in terms of multiple jurisdictions, that gives rise to resource co-specialization opportunities. And because of these opportunities, the firms here, the commercial corporations, would want to rely more heavily on the insourcing of legal resources. So I hope that's a kind of step that is logically clear enough. And, obviously, if you're GE operating in 130 countries as opposed to some domestic utility company that has only the United States in mind, then we're just saying that there are lots of inter-jurisdictional synergies that an in-house lawyer can actually think of much, much better because of their proximity to the corporate planning department or to the accounting department, as opposed to a law firm that happens to be in a particular country in one of those multiple jurisdictions. Yeah?
If you're operating multiple jurisdictions, multiple places, that you also have the opportunity to place centers of excellence in some of those jurisdictions as well. So it would strike me that GE, for example, because it's operating in India, would then feel more comfortable in having a center in India to do some of this work, which would in turn mean that it could channel. In other words, that it would look around the globe and say, that's a very good place for us to put all of our legal work. And so you would feel more comfortable about it, see the logic in terms of this. Does that make sense? So it's not just that it's about the opportunities to arbitrage, but the opportunities to use resources in particular countries.
Yeah. So any large corporate general counsel office seems to have a headquarter function, like corporate transaction and litigation. They tend to be centralized, whereas into the, I'm not sure whether they're centers of excellence, but they're sort of regional or country-based legal offices, which tend to be delegated specific responsibilities as well. The ones which are centralized are the ones where I think the co-specialization opportunities exist. Yeah, so that's what I'm, yeah.
I'm wondering whether there's another element, which is that possibility of grabbing excellence in that area, whether that might also drive. In other words, if you were based entirely in the UK and you were trying to figure out a way to drive costs down, you might say, well, hiring lawyers in the UK is going to do it. But if you also have to have a center in the Philippines or something,
that doesn't, for example, presumably do the same, just hiring an external law firm in the Philippines.
You could. So, but the argument could be that somehow because of your comfort in being in that place, I don't know. Okay, so
I mean, I can see the cost arbitrage reason for doing that, but I mean, unlike in technology areas where you might have center of excellence in mechanical engineering in one country and center of excellence in some other technology in another country, that with legal expertise, because every country might have different systems of law, it might be a bit difficult to think of centers of excellence that would be center for the global, excellence in the same way that technology might be. Yeah. Yeah, but it's worthwhile thinking for sure. Yeah. Okay. And then the next set of hypotheses, which are to do with R&D intensity and advertising intensity, the co-specialization opportunities that arise from these two are pretty straightforward. So the argument here is that if you're an in-house legal department, an in-house lawyer, you have a much better understanding of the business context, of course, and the particular sets of technologies that the corporation has been developing and putting R&D resources into. So the in-house lawyers, as compared to an out-of-house lawyer, would have a much better understanding, a tacit knowledge in terms of, what to patent and how to patent, and as a result, likely lead to better intellectual property protection than otherwise. And so because of the co-specialization opportunity between R&D intensity and legal resource, that we'd expect R&D intensive firms to rely more greatly on in-house legal resource. And in a similar way as well, advertising with brands and copyrights, that's another set of intangible resources, so we'd expect another sets of co-specialization between, in this case, the legal department and the marketing department, that opportunity to lead to greater reliance on internal legal resources. So I think that's pretty straightforward. And then the penultimate hypothesis, which is about the general counsel on top management team. I think this is quite interesting. So there's people like Connie Bagley, who's been writing about legal astuteness for some time. And this is really kind of looking at the corporation from the perspective of the top management team and their ability or the dynamic capability to be able to communicate effectively with the legal counsel, to be able to work together to solve complex problems. So the proposition here is that having a general counsel on the TMT is a sign of legal astuteness. And we argue that legally astute corporations can better exploit opportunities for co-specialization, again, between legal and other resources, because you have a GC that seems to have a management function as well, and they're better tuned to the business context, the business strategy, and so they can realize value of intangible assets in the way that we talked about with intellectual property or brands, but also really think more kind of proactively about, how to use legal tools, create options if you're facing litigation, out-of-court settlements, for example, and, convert regulatory constraints into opportunities, particularly in things like environmental regulation. Okay, so our hypothesis here is that if lawyers or general counsel are on the top management team, by having a title like senior vice president or executive vice president, then it's associated with greater reliance on insourcing of legal services. Yeah.
Just the GC, the current GC, being currently a member of the current management?
Yeah, so there are different ways in which we try to look at the data, but the one that we kept and have focused on is the general counsel, which also has a management title like executive or senior vice president. We also looked at GC on the board of directors, and then I think we could also probably do, board members who have a legal training, whether they had been a GC elsewhere or otherwise. But this is just one of a portfolio measures but yeah. Okay.
Obviously, one could imagine that in-house counsel became incredibly powerful. They want representation at the board. It might be thought.
Sure. It is a problem. It's a, I mean, the endogeneity of some of the variables is a real issue. But one thing that one could say is that I think a really prevalent explanation of GC on top management team is to do with precisely status and power. And what we're trying to say is that there is an equally, viable alternative explanation other than power and status that would explain the variation across different companies, because power and status is like, everybody aspires to have more power and status, so you should have, so there is a bit of a difference in the actual explanation that we're trying to pose. Okay, and then lastly, this is the last hypothesis before we go into the data. So I think it's interesting to understand the link between the relationship with law firms on the one hand, and how much you insource or outsource. And in the traditional analysis, we think of the composition of, supplier portfolio, how many suppliers you're going to contract with, as being independent from the choice of the degree of insourcing or outsourcing. So, if you do a traditional transaction cost economics analysis, then you have kind of step one, look at the transactional characteristics and choose the boundary of the firm, firstly. And then step two, decide how many suppliers you want to contract with. And what we're saying is that the two are kind of interdependent. You got to kind of, and here is also the indigeneity problem as well. But, if the two are interdependent, then one can argue that if there's a large number of law firms in a panel, which is the normal word that lawyers use for the bunch of law firms which are retained and they get reviewed from time to time, but they are assured a certain amount of work over the years, then the mundane transaction costs are going to be higher from the perspective of the corporation, and as a result, we prefer to rely a lot more on insourcing of legal services. That's just applying a very standard transaction cost economics, calculus. Higher the transaction cost in the market, the more you rely in-house. So conversely, if you have a small set of law firms in a panel, or you've done a panel review and really kind of took conversion seriously, then the benefits from relational contracting in terms of, relationship based on trust and lower transaction costs of mundane kind will be higher. And that allows the corporations to rely more heavily on the outsourcing of legal services. So that kind of feels a bit counterintuitive to start with, but that's really the relationship that we wanted to test, and indeed happy to say that we do have some evidence to show that is the case. So without being too tedious about the data and sampling, but huge amounts of work normally goes into this kind of thing, and thank you to George for taking a lead in this. We actually came across this ALM Legal Intelligence survey that basically count the number of in-house lawyers at Fortune 500 companies over a number of years. And we took the period 2004 to 2009. Obviously, it's better if the period is longer, and hopefully we can do that later. And then we matched that with some of the firm characteristics using CompuStat and Capital IQ data as well. And obviously the interviews that I've done in Britain and the US are there to inform the interpretation of the data as well. So the dependent variable is the ratio of the count of in-house lawyers over sales turnover, and taking a natural log of that. And I'll explain what controlling for the overall amount of the legal work undertaken by firms mean in a minute. But then there is a whole load of independent variables, one of which is internationalization. Many different ways of doing that, but we just took the count of the number of countries where each firm operates via subsidiaries, because that gives you the number of jurisdictions, and for a legal kind of work, it makes the most direct sense to count that. R&D intensity, just the R&D expenditure over sales, advertising similarly over sales, general counsel, I think I've already said how that's defined, and then just counting the number of law firms, pretty straightforward as well. So slightly different way of looking at it. So dependent variable, we wanted to have a continuous variable, so that's how it ended up being the head count divided by sales, and the control. So the amount of legal work that could be done in-house could be increased in one or two ways, one of which would be to bring what had been done out of house to in-house. The other one would be just the size of the pie has gone up, so everybody's working harder, both the out. So in order to control for the latter case, we did a count of the new litigation cases, new acquisitions in a particular year, to account for the overall increase in the size of the pie. Also, sales, general, and administrative expenses, just to give a proxy for the legal expenses. We haven't got the dollar sum. That's the real kind of problem with this particular data. And then also there's a dummy that is one if the company is going through bankruptcy proceedings, because that also gives a very good indication of the amount of legal work that you have to do. Okay, but these are the simple kind of sets of explanatory variables with a huge number of controls for which you want to look at some of the science for. So let me go through. It's amazing how the time goes very quickly. The econometric specification. I'm kind of looking to George for some help here, but so it's a panel data. We can actually do the standard fixed and random effect specification to, allow us to control for unobserved farm characteristics. But even with doing that, there are two further issues that we have to take into account. One of which is that because it's over time, the current in-house lawyer count is likely to be influenced by past in-house lawyer count. Also, as Chris pointed out, some of the independent variables may be endogenously determined or predetermined. So it's correlated. So one of which is top management team, the GC, could be the fact that, because there are more lawyers, they want power and status, and that's why they appoint the GC to have a management role. Another example might be to do with the fact that the legal expense is really part of the general sales and administrative expenses, so they'll be correlated as well. And the number of law firms could also be correlated in some way. So in order to address those two issues, we use this dynamic panel data estimator with GMM type instruments, where because of all kinds of instrumenting and missing values as well, we end up with an N, which is 945, but that's still large enough to try and get at what's going on. Happy to come back to this, and George can answer all the difficult questions. But I think it's probably useful to have some kind of visuals before we go into the economic data, or maybe we can dwell on the visuals. So this is really simple box plot diagram where the middle line is the average, and then it's the maximum and the minimum. These are dots are kind of outliers, and then this is the is it the first quartile? Yeah, and median. And then the 25% below the median. And the vertical axis is this complex calculation of the natural log of the lawyers over sales. So on average, we had that number to be 5.37, which translates into 3.62 lawyers per a billion sales. So it's not a huge number, but you do see some sectoral differences in the number of lawyers there. Also, if you go to your question actually about the kind of change over time, we don't see a huge amount of change over time. The vertical axis still continues to be measured as natural log of in-house lawyers over sales. So that's the situation. And then there's a whole load of one-by-one sort of simple regressional correlation really here, and looking at the number of countries and in-house lawyers. There's a somewhat upward trending line there with a red line there. So the yeah. So although this doesn't look impressive in actual fact, and if you had the numbers on the vertical axis, it will be a much steeper line. Yes. It's the number of countries where subsidiaries exist, whether they're operating or non-operating. As long as there's a legal entity in that country. That's what the data shows. Is that correct? Yeah. Is that an issue, do you think?
Barclays has 30 subsidiaries in the Cayman Islands. Would they still have 4 lawyers?
Well, this data seems to show that on the whole, those subsidiary counts would add to increasing the number of in-house lawyers. Yeah. Yeah.
Well, that's part of what we're trying to explain. So the fact of what we're saying is the fact that you have many lawyers, let's say, in the Netherlands, allows you to take advantage of this kind of tax planning and essentially being able to pay less tax. So this is why you have them in-house as opposed to use a law firm because they understand the concept. But on top of that, we can measure it in different ways. We can measure so the other properties that were in kind of grouped different jurisdictions in terms of kind of legal framework. So you have one from Anglo Saxon, one from Central Europe. So even when you account for kind of similarities in that sense, still the results hold. But I think again, like it doesn't matter in terms of whether it's operating or not, because what we're actually trying to say is that if you have presence there, then that should create opportunities. Maybe the opportunities are operational, maybe not, but that's what we're focusing on.
With the 30, you would collapse into one instance, right? So if you had 30 subsidiaries,
exactly.
you would only have one country in which you were operating in a sense in one account. So the number
But how,
per place is bad.
but how common is that?
Every single structured product is set as an individual entity, and then you might have the leverage, blah 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 fund, blah 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 other fund. The reason I was asking about the operating versus just being default tax or other reasons is say you have 10 operating subsidiaries in 10 different countries. And I suppose it goes a bit in the direction of this question of causality, directional causality. So you start having 10 subsidiaries in 10 different countries. And then you realize that you have the potential of post-specialization, and then you start building up your law firm, your in-house resources to take advantage of these, or you start out having, say, only one or two operating subsidiaries abroad, but you get one clever runner says, oh, wait a second, if we set up a holding company, Caymans, and we can sort of offset on the profit and loss over these two, and then you start building the structure so the causality might be flowing the other way. That being international is not necessarily a trigger for the realization of post-specialization potential, but just you see a guy who had a clever idea, and as a result of this, you become international via tax structures rather than operating subsidiaries.
Yeah. Yeah. At the margin, I can see that that's the case. But are there cases where non-operating subsidiary numbers bigger than the operating subsidiary numbers? Relatively speaking, I would have thought that non-operating would be a smaller number. But at any rate, I mean, we could probably at the margin think about the causation going the other way. So that's an interesting point.
But again, we can control for that, we can control for this potential to generate. I mean, like the fact that it earns more lawyers makes it more international. I'm not sure if that's, well, maybe, but the question is we can control for that and it's still fine. What we're suggesting, but I don't think that's clear. I mean, I don't see how like a firm with a lot of lawyers would necessarily become more international. I mean, I don't know.
Yeah. All right, let's leave that for now and go to a slightly more straightforward cases where, so the more are in the intensive along the horizontal axis, the higher the in-house lawyer number. And similarly with advertising as well, where actually the relationship is pretty strong. And then this is an interesting one where, GC in top management team, if the answer is yes, then you tend to have a larger number than if you said no. This is an interesting combined diagram where we took a group that had above median for all of these co-specialization variables, so internationalization, R&D intensity, advertising intensity, and GC in TMT, which is this right-hand box plot, compared with the group that had below median for all of those four variables, and you see a distinct difference in the number of lawyers, and then the remaining group somewhere in the middle. as well. So that's the co-specialization result.
Yeah, the part that's even more surprising, interesting is how that group on the right is tighter, right? So it's not just it's higher, it's tighter. You're about to get that.
Yeah, yeah, yeah.
Because that was
Yeah, that is interesting. Yeah. Okay. And this is the last hypothesis around law firms, and you can see that the number of law firms over time, not over time, is again, correlated with larger number of in-house lawyers. So intuitively, sometimes you might think of these as substitutes, that the more work you do in-house, the less number of lawyers. Although arguably, we're not actually measuring apples to apples, because on the vertical it's the number of lawyers, whereas on the horizontal it's the number of law firms, regardless of how many lawyers you're using. It's difficult, but anyway, in this relationship there is a thing. And to be more clear, you could think about sorry, that label on the horizontal axis isn't very clear, but above median, meaning that if the number of external law firms is above a median for the sample, then you have a larger number of in-house lawyers than otherwise. Okay, so those are the kind of variable by variable result, which if you put them together in an econometric procedure with various controls, but the ones that I guess we should be concentrating on is the 4 and 5, where we actually find the number of countries, that's internationalization, significant at 1%, advertising significant at 5%, and the rest, R&D intensity, GC and TMT, and number of law firms significant at 10% in the expected direction. Okay. So I guess I will conclude by just saying a few words about the implications, and really that's where I think we also can do with a bit of help as well. So I think on the whole, regardless of whether this was about the legal services or not, I hope that we've done at least 2 or 3 things. One is within the strategy research to really sort of think about moving away from identifying the preconditions for the coexistence of multiple sourcing modes to kind of understanding specific strategies which are present in deciding the mix of make and buy in the sourcing. So that gives us one step in terms of doing some theoretical work, but also empirical work, and really identified resource co-specialization and supplier portfolio concentration as 2 potential mechanisms for understanding those variations in insourcing and outsourcing mix in plural sourcing. The other thing that we've done is to really understand what would be a useful unit of analysis for kind of understanding this kind of phenomena of multi-sourcing, and away from a transaction cost economics, where we sort of think about one transaction at a time as a unit of analysis, and away really from the resource-based view or the capability-based view, where you treat the entire corporation as a unit of analysis. We want to kind of sit somewhere in the middle. And it's actually not a very comfortable middle, because we haven't really theoretically nor empirically said what would be the good level of analysis. But at least it's a move away from a single transaction to portfolio transactions to identify some patterns of interdependence that would create complementarities and synergies among different kinds of transactions and firm resources. I mean, I would say that if one were to go all the way down to the level of detail and lower the level of transaction to a single activity, then logically only one person could be doing a particular piece of legal work at any particular point in time. That's kind of like an infinite regress, logically ludicrous analysis to take on. So we want to rise from that to some level, and how high to rise is something that we want to kind of theoretically refine from now on. And then lastly, thinking about corporate function, which, tended to be understudied because they're just overheads, support activities, to really sort of thinking of this as equally important as primary activities in analyzing make and buy decisions. And lastly, for those of the people who are really concerned about the legal context, I think there are some practical practice-related prescription that arises out of our findings too. And that's to say that, with all this talk about, the need for legal costs to be controlled, to do more for less, and the importance of panel convergence and all these things as well. There is a variety, and not everybody should be doing the same thing. There's no one size fits all kind of solution. So what we've actually found is that insourcing and actually creating a larger in-house legal department makes a lot of sense if there are opportunities for co-specialization in terms of being R&D intensive, in terms of being advertising intensive, in terms of being very internationalized, or in terms of having your GC be a part of a top management team, and also only if you think that your relationship with the suppliers in terms of law firms is very good, so that you can really put your eggs in a basket with fewer law firms. So those are the preconditions for being able to rely a lot more on the in-house resources, or rely a lot more on outside resources. You have a fewer set of law firms. I think that's probably all I want to say for now, and I've spoken for a long time, so I'm not sure how you would like to manage the Q&A, Roya, but we obviously have some questions here. So shall I start with questions around the table, yeah? Yeah. Okay.
Let's thank Laurie.
Okay. Thank you.
One second. So thanks a lot for listening online. It was great having you here. If anyone has a question, send an email to Professor Marisako. Thanks a lot for listening. Bye.